Hi, my name is Akiva Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law and family law issues. Please subscribe to our channel. What do we do if we're trying to serve somebody and your soon-to-be ex-spouse is deliberately evading service? What do I mean by that? I mean that you engage a process server to serve them with papers. The process server knocks at the door, can hear them running around, acting like they're not home, like they're preparing for a surprise party, and they don't let them in. So they come again, the person denies their identity. Oh, it's not me. Oh, you got the wrong person. You know, they're evading service. The process server comes to the door, the person runs out the back door. What do you do? Well, our core rules are not set up to encourage or certainly not promote evading service. So what you have to do is, when you have a situation where the person is evading service, the process server will typically file an affidavit indicating I tried to make service these 3 times and this person is evading service. This person threw garbage at me. This person sicked their dog on me. Whatever it is, your attorney will then file a motion for substituted service, attach the affidavit, there will be a hearing, and your attorney will basically say to the judge, look, you've got to give us another method of service. This person is deliberately avoiding service of process, and that cannot hold us up from our custody battle, our divorce, whatever it is. There are options that the court has to allow people to be served by means other than handing them the papers. There is publication. There is alternate service. There's tacking the notice to the door. There's email services, all sorts of things that the court can do if it wants to. Really, if you think about it, the person who's evading service is actually playing right into your hand. Because if they got the papers, they would open them up, they'd read them, they hire their lawyer, they do what they need to do to assert their position, to be heard by the court. By evading service, they're basically saying, I'm not touching this. It's like people believe they don't go to a doctor, they'll never be sick. I'm not reading this, so it doesn't apply to me. Well, that's stupid, because the court is going to allow alternative service, maybe published in the legal news. The person's not going to read the legal news, because even lawyers don't read the legal news, and the person's never going to know that they're being sued, never going to have actual notice of what they're being sued about. And then when an order comes in giving the other side 100% relief and you get nothing, you're not going to be able to in a position to come and claim, oh, well, you know, I didn't know, blah, blah, blah. Because the court is going to see that record. It's going to say, wait a minute, 3 efforts were made to serve you and give you these papers, and you ran out the back door. You know what? You're not entitled to relief by the court. And so, in other words, what the person is doing at the outset, maybe making your life more difficult, maybe ramping up the costs because now you got to spend more on motions, but in the long run, they're doing you a favor because they're not going to be able to participate in these proceedings. And a proceeding which only has 1 participant is a very short proceeding. Whereas a proceeding where 2 people are actively going at it, that could go for months and months and months. So in that situation, you tell your lawyer that your service was not achieved. If it's a process server that your lawyer engaged, your lawyer's going to know what's going on. Appropriate motions will be filed to address the need for alternate service. If you have any questions about that, reach out, give a call today, and we'll be glad to help you out.